Thank you all for joining us this afternoon. We're really lucky to have Ronojoy Sen with us today. I think he's probably known to many of you, but maybe not all of you, so maybe I'll embarrass you a little bit by taking advantage of your CV. Ronojoy did his BA in history in Presidency College and then did a master's degree at USC, not the one in California, but the one in South Carolina, in government, and then finished his PhD in political science in 2005. He's currently a visiting senior research fellow at the Institute of South Asian Studies at the National University of Singapore. He has published one book already, and the second one is almost out. Is that right?
Yeah.
The first is called Being Muslim in South Asia, Diversity and, the first is called Articles of Faith, Religion, Secularism, and the Indian Supreme Court, which is an OUP book in 2010. And there's a new book coming out from Columbia called The Games We Play, A Social History of Sport in India. There's a number of edited volumes, including Being Muslim in South Asia, Diversity and Daily Life, and a book called India of Ideas, 175 Years. There's also numbers of articles in a wide variety of publications, including the Journal of Asian Studies and Pacific Affairs and South Asian Journal and South Asian History and Culture. I also noticed that Ronojoy has recently, a few years ago, been a fellow of the International Olympic Museum in Lausanne. I must say I don't know exactly what that means, but my imagination has been taking me places, and I hope you can tell us about that at some point. Maybe not during your talk. It may not be appropriate to talk about the luge or whatever it is you were doing there. Today, Ronojoy is going to talk about some work from an ongoing project, I think. Is that right? Or is this a recently completed one? I'm not sure.
It's an ongoing one.
An ongoing project, and the title is Pious Wishes, Observations on the Directive Principles in the Uniform Civil Code. So please join me in welcoming Dr. Ronojoy Sen to Harvard and to our seminar series.
Thanks, Parimal, for that generous introduction. I must apologize. I'm down with a pretty bad cold, so the voice is not functioning as well as it should. I hope you can hear me. So I've actually made my PowerPoint slightly more wordy than I might have normally to compensate for my lack of speech. And I also would like to thank not just Parimal but Shankar and the staff at the South Asian Institute for getting me over to Harvard. Since Parimal was mentioning the status of the work that I'm presenting, I should briefly preface the presentation by saying that I've done some earlier work on the freedom of religion clauses in the Indian Constitution. And in relation to that, I've actually looked at the Uniform Civil Code issue. I'm currently engaged in a project on the Parliament and the legislative process. And this is one of the angles from which actually I'm engaging with the Uniform Civil Code issue, and not so much with in the perspective of freedom of religion. So I'm really interested in the legislative process and the Constituent Assembly debates. So I'll briefly be looking at some of this before going into some of the Supreme Court judgments, both on the directive principles in general and Article 44 or the Uniform Civil Code laws in particular. So let me just briefly run through some of the relevant constitutional provisions, because with these articles it's sometimes difficult to keep track of, which is which. So the directive principles, as some of you are already aware, is Articles 37 to 51. Article 37 is the one that says the directive principles, as opposed to the fundamental rights, are not enforceable by any court, but nevertheless fundamental in the governance of the country. So there is an inherent tension built into the article in the way it's framed. Article 44 is the one that relates to the Uniform Civil Code, and it says the state shall endeavour to secure for the citizens a uniform civil code throughout the territory of India. Article 21 is actually a fundamental right, and I just put it here because there will be reference to that later, since the court uses Article 21 in its directive principles jurisprudence, and it's a very pithy article. It says no person shall be deprived of his life or personal liberty except according to procedure established by law. So a little bit about the Constituent Assembly before I move on to the directive principles and the Uniform Civil Code in particular. As again some of you are aware, the Constituent Assembly was not elected by adult suffrage as the Congress had long wanted, but by the provincial legislatures, but based on the provincial legislatures elected in December 1945, just 2 years before Indian independence. The provinces were to be represented in the ratio of 1 to 1 million of the population. India in microcosm was a famous term used by Granville Austin in his landmark, Indian Constitution, Cornerstone of a Nation. He used that to describe the Constituent Assembly, even though it was not elected on universal adult franchise, on actually a severely restricted franchise. And not only was that one problem, the other was, of course, it was dominated by one party, the Congress, and especially with the departure of many of the Muslim League members after partition, the Congress majority jumped up dramatically from roughly 69% to the early 80s. But why Granville Austin used the phrase India in macrocosm, one of the reasons was he was very impressed by the approach of the Congress in making the Constituent Assembly a bit more representative than it might originally have been. And this they did by nominating many members who were not congressmen but were eminent personalities. Of course, Ambedkar was one prominent example. There were several others like K. Munshi, H. N. Kunzru, N.G. Iyengar. And the Congress also ensured that the minorities got reasonable representation. So and this is important, particularly in debates on the minority rights and the Uniform Civil Code issue. So the minorities, a majority of the Muslims, held 88 of the 235 seats allotted to the provinces. There were three political organizations that were notable in their absence: the Communist Party, the Socialists, and the Hindu Nationalists. But one must remember that the Congress itself, being such a broad umbrella organization, there were several, of course, socialists as well as Hindu nationalists, within the Congress itself. So that also, in some ways, compensated for the absence of these parties. So on to the history of the Directive Principles. The Motilal Nehru Committee report, as many of you are aware of, in 1928, was really a sort of landmark event in India's constitutional history and the framing of the Indian Constitution. And it drew up a list of political, civil, social, economic, and cultural rights. The Directive Principles itself can be traced directly back to the 1931 Karachi Resolution passed during the annual Congress session. So in 1931 it was held in Karachi, and it was an important statement outlining social and economic rights, some of which would find place in the Directive Principles. The principles of social policy in the Irish Constitution, the 1937 Irish Constitution, were actually inspiration for India. Sir B.N. Rao, Benegal Narsingh Rao, the constitutional advisor, actually made a visit to not just Ireland but US, UK, sometime in the 40s, and he does talk a little bit about the importance of the Directive Principles, but he doesn't. At least I haven't seen anything where he goes into great length as to how the Irish Constitution was an inspiration. He just sort of mentions it, that they were an inspiration. So that's a bit of a puzzle. Maybe some of you might have clues as to what exactly the Irish influence was on B.N. Rao and the others. Now the debate on the Directive Principles in the Constituent Assembly itself. There was some, particularly the trio of Ambedkar, who I mentioned, and K. Munshi and K.T. Shah, who were strong proponents of Directive Principles. Munshi and Shah were particularly interesting figures. Munshi, the lawyer by training, the president of the Bharatiya Vidya Bhavan, that sort of brought out a series of books on Hindu culture and Indian culture in general. And K.T. Shah, not much sort of written on, but I think with this sort of renewed interest in the Constituent Assembly in recent times, I think some of these remarkable figures are being fleshed out. I think we were very much used to just sort of quoting their names without really going into who some of these people were. And K.T. Shah, a socialist economist, again I think a barrister by training, and later a professor of economics at the Bombay University. Probably the first professor of economics at the Bombay University. So these three members were very much strong proponents of not only the directive principles, but of making the directive principles justiciable. And they were very much against the separation of justiciable and non-justiciable rights. Ambedkar, even in 1947, while the assembly debates were on, was in favor of this, but by late 1947 he had changed tack and changed his position. And it remains a bit of a puzzle, and this we can discuss later in debates, why this happened. I just quote Ambedkar here, where he says, at a point when he's actually decided, made the decision that the directive principles should be non-justiciable, and he justifies it by saying that even though the government of the day might not be answerable for their breach in the court of law, they will have to answer to the people or the electorate if the directive principles were not implemented. So it's an interesting stand that he took. There were, of course, several critics of the directive principles in general, and some who were critics of actually making it non-justiciable. T.T. Krishnamachari, more famous not so much for his role in the Constituent Assembly, but later as finance minister in the Nehru government, and his links with so-called first corruption case in independent India, the Mundra or the LIC scam case, and he called the directive principle a dustbin of sentiment. And there were others like Nazaruddin Ahmed, a Muslim member of the Constituent Assembly, who called them prize principles, which meant nothing if they did not have the backing of the law. Sir Ivor Jennings, quite remarkable figure of the time, a leading constitutional scholar who, in fact, was associated quite influentially with two constitutions in Asia. One is Ceylon or now Sri Lanka, and the other of the Malaya Federation. So Ivor Jennings, in a very slim book on the Indian Constitution, described Article 37, which I referred to earlier, which makes the directive principles non-justiciable as pious aspirations. So very much using the language of some of the Constituent Assembly members, and making a point, about the appearance of piety, which he felt was encapsulated in the directive principles, helping to capture votes. So this is in some ways directly going against what Ambedkar believed, the government being answerable to the people on enforcing the directive or implementing the directive principles. Right in the early years of independent India too, the tension between the fundamental rights and the directive principles came up very, very soon after independence. And this is during the First Amendment debates in 1951. Nehru brings it up in what is a very fascinating debate, not where Nehru contributes in a big way, but there are several others, including Shyama Prasad Mukherjee, who contribute, and where Nehru makes the point strongly that the directive principles are dynamic, according to him, compared to the fundamental rights, which he describes as static. And this was, to some extent, prompted by the court rulings, early court rulings, Supreme Court rulings, as well as some High Court rulings at the time, which was striking down some government initiatives, particularly on abolition of zamindari, on land sealing laws, on reservations or quotas for the weaker section of society, and the Congress agenda, as Nehru saw it, was being frustrated by the Supreme Court, and this was where the directive principles was brought to the foreground. Just to switch back now to the debate on Article 44, in particular in the Constituent Assembly. The debates again in the Assembly repeated powerful voices both for and against the Uniform Civil Code, as was the case with the directive principle itself. The draft articles on justiciable rights proposed by both Ambedkar and Munshi alluded to a Uniform Civil Code, and Ambedkar was a very committed proponent of a Uniform Civil Code, and the entire nation claiming full and equal benefit of all laws and proceedings. But there were several objections, and particularly from the minority members, and there were 5 Muslim members who participated in the debates on on Article 44, and I just quote a couple of them. Muhammad Ismail Sahib mentioning that people are not obliged to give up their personal laws, and Mahmud Ali Beg giving his own interpretation of secularism, saying that a secular state does not mean that a common law has to be observed by all citizens in all matters. And in fact, all the 5 Muslim members, mentioned sort of variations, their arguments or variations of this theme. So that was the Constituent Assembly, and again, as India becomes independent, and in the early years of independent India, the Uniform Civil Code issue, like the Directive Principles, comes up very soon, and this is one of the major sort of landmark legislations in independent India, the codification of Hindu law. And what I haven't actually mentioned here is, not just the Uniform Civil Code, but the codification of Hindu law was also a very important principle for Ambedkar, and that was really the ground on which Ambedkar resigns as a law minister in independent India. So that's the ground. What happens is in the elections, in the first elections in India in 51, early 52, the codification of Hindu law is one of the electoral campaign issues for the Congress, and Nehru and the Congress take up this issue in right earnest during the tenure of the first Parliament. What they do is, instead of having one comprehensive Hindu code bill, it's broken up into 4 separate parts, and this then gets passed in Parliament, but not without a very acrimonious debate. And again, this is a Parliament where the Congress does have a fairly strong majority, but the opposition is vocal, and the Hindu Mahasabha's N.C. Chatterjee, incidentally the father of long-time Speaker Somnath Chatterjee, raised an important issue as why the personal laws should be confined to Hindu society alone. And from the other end of the ideological spectrum, Acharya Kripalani, who was quite a sort of thorn in the side of on the Congress and Nehru during the period, talks about the Hindu community not being prepared for divorce. So why shouldn't the Hindus be separated and singled out for reform? So those were the sort of 2 ends of the debate on the codification of Hindu law. The criticism was countered by a gradualist argument by the Congress government. The then Law Minister H.V. Pataskar, who not particularly notable for other things, but he's sort of well known, at least for being the Law Minister who gets who's in charge when the codification of Hindu law happens. And his view is that if 85% of the people does have some sort of a codification of law, this would constitute a big step towards eventual uniformity. And Nehru himself famously says that the time is not ripe enough, and this is something that sort of comes to haunt the debate on the Uniform Civil Code, because if one was sort of to go back, probably that was a time when the Uniform Civil Code could have been pushed through, hypothetically, with the Congress dominance, with the stature that Nehru had. And since then, the no government really has had the gumption or the legitimacy to push through something like this. And Nehru himself felt that this prepared the ground, the codification of the law prepared the ground for an eventual Uniform Civil Code, and that was his opinion. But the Congress does not come back to that to move on that, at least during Nehru's time, and of course afterwards. So let me just briefly run over the jurisprudence on the Directive Principles, and it's a fairly elaborate one and long-standing one. In fact, it goes right back to 1951. Fairly landmark case with people who are familiar with the with legal history of India, the Champakam Doyarajan case, which dealt with the legality of reservations or quotas in educational institutions. And there, the Supreme Court says the Directive Principles of state policy have to conform to and run subsidiary to the chapter on fundamental rights. So early on, although the court does in different cases take somewhat differing stance on the right principle, but this is a reasonably clear statement in one of the earlier court rulings. There were legal scholars like P.K. Tripathi, who strongly argues that the directive principles could not be made subservient to the fundamental rights, and in a quite famous 1954 article, he attempted to show that directive principles do not constitute a set of inferior and subsidiary principles. And again, Tripathi's position is reflected in some of the court rulings later. There is a change in the court's direction from the 60s onwards. In the Golaknath case, which in some ways is the basis for the essential structure doctrine, says that it is wrong to invoke that the directive principles, as if there's an antinomy between the directive principles and the fundamental rights. And a few years later in Keshavaranda Bharati, probably one of the most well-known constitutional cases in India, the relationship is decisively reversed. And it's, of course, people who have read that judgment, it's one of the, not only the longest judgments, it's also a fairly confusing one, with all the 13 judges writing separate judgments. And one of the judges they're saying is that there's a duty on the courts to interpret the Constitution and the laws to further directive principles, which under Article 37 are fundamental in the governance of the country. From the 1980s, there is what might be called an Article 21 revolution, and remember I'd mentioned the Article 21 in the first slide, just to go back. No person shall be deprived of his life or personal liberty except according to procedure of law. So here, from the 1980s, what happens is the court moves beyond the idea of opposition between fundamental rights and directive principles, and the question of whether the latter is justiciable or not. And in a series of cases, the courts brings into play a very expansive interpretation of Article 21. One of these sort of early cases is a case related to labor in a quarry, bonded labor, in the Bandhuva Mukti Morcha case, where Justice P.N. Bhagwati, who is one of the central figures in the 80s Supreme Court, not just for interpreting the directive principles vis-a-vis Article 21, but also a central figure in the public interest litigation revolution, which is happening at the same time. And in fact, one could argue that both sort of feed into each other. And the court uses Article 21 to press for a range of rights, including the right to clean air and water, shelter, health, education, food and clothing. And these are all there in the directive principles, but now the court is actually using these to sort of make them enforceable. And there are several judgments, and I don't want to go into the details, and Olga Tellis, Unnikrishnan, which are then brought to bear on the directive principles. And this is through the beginning in the 80s, and this goes through the 90s, and in fact it continues. So now look at the jurisprudence on personal laws, which is not, one would say, as well developed as the jurisprudence on the directive principles. The first case where the question of personal laws for Muslims comes up is in a 1952 case, the State of Bombay versus Narasso Pamali. Here what was being judged was the validity of the Bombay Prevention of Hindu Bigamous Marriage Act 1946, was a challenge before the court. Here the Bombay Chief Justice M.C. Chagla stated at the outset that personal laws could be reformed in the interest of state policy. He, however, conceded the validity of personal laws. So he takes a fairly nuanced stand, saying that the laws could be reformed, personal laws, but it's not as if there's something inherently legitimate about personal laws. Justice P.B. Gajendra Katkar, who later goes on to become the Chief Justice of the Supreme Court of India, But then a judge in the Bombay High Court concurred, saying that the Bigamous Marriages Act did not violate equality before the law. And using Nehruvian language, the sort of language that Nehru uses, actually, this judgment is before the debates on the Hindu Civil Code. Sort of, in some sense, he anticipates Nehru's language, where he says that the Hindu community at the time was more ripe for the reform in question as compared to the Muslims. So the Court and the Uniform Civil Code, from the 50s actually till the 70s, there's really hardly any court cases related to the personal laws and Uniform Civil Code. It's only in the late 70s, a few years before the now infamous Shah Banu case, which I'll refer to shortly, the Supreme Court has to examine Muslim personal law in the right of a divorced Muslim woman to seek maintenance from a husband. So the first case was one called Bai Tahira versus Chotia, where a divorced Muslim woman moved the court under Section 125 of the CRPC, the Criminal Procedure Code, which really the 125 to 127, the relevant sections deal with maintenance of a divorced woman. And here Justice Iyer, who was again a fairly notable figure in the Supreme Court, ruled that a payment of mahar or dower was compatible with the relevant provisions of the CRPC. And although he introduced the caveat that the payment paid must be reasonable, it just couldn't be a sort of arbitrary sum. So there was no, in both this case and a later one, which is actually a year later, in Fuzlun Bai versus Khaderwali, the court does not bring in or does not mention the Uniform Civil Code at all. It interprets the issue of maintenance, looking at the CRPC provisions as well as the provisions under Islamic law. But in the Shah Banu case in 1985, 5 years or so later, the position is somewhat dramatically changed in terms of the court's ruling. And here the issues are similar. Again, a divorced Muslim woman suing her former husbands for not providing adequate maintenance under Section 125. But here, Chief Justice Y.V. Chandrachud, who's interesting because he actually, I think, had the longest tenure as a Chief Justice, if I'm not wrong. Mother was, yes, which is an outlier because there are very few Chief Justices who've had that kind of a tenure. And he framed the case as illustrating a potential conflict between the civil and criminal laws of the country and gender rights on one hand and Islamic law on the other. So he was taking a different position from what Justice Iyer had taken in the earlier two cases that I cited. And Y.V. Chandrachud also cites the Quran and a couple of interpretive texts from the British era on Islamic law and to affirm that the right to maintenance of divorced women did not clash with Muslim personal law.
That's your first question.
Yeah.
The sections are under the chapter 21, article 21.
No, the sections are actually under the Criminal Procedure Code. No, that's the
That's a different.
Yeah, that's different. Yeah, that's the Criminal Procedure Code.
Oh, okay, it's different.
Yeah, it's not part of the Constitution. Yeah.
Great, thanks a
Yeah,
lot.
that's a CRPC. Yeah. Sorry, I should have clarified that. So, so to briefly go over some of the post Shah Banu cases which really have followed the line taken by Justice Chandrachud in Shah Banu. So there's one which a decade or so later, Salla Mudgal, where the court rules that Article 25 and Article 44. Article 25, I should mention, is the one that guarantees religious freedom. Articles 25 and 26 are really the freedom of religion clauses, and here the court rules that whereas Article 25 guarantees religious freedom, Article 44 seeks to divest religion from social relations and personal laws. Again, in 2003, the Supreme Court articulates the need for a uniform civil code, much like Justice Chandrachud in Shah Banu, in a case John Valamottam, which is actually not to do with Islamic law, but it's got to do with Christian inheritance laws. And here it says that Article 44 is based on the premise, and this is a fairly strong statement, saying there's no necessary connection between religious and personal law in a civilized society. And in obiter dicta, very similar to Shabano and Salah Mudgal, the court says that it's a matter of regret that Article 44 of the Constitution has not been given effect to, and the Parliament is still to step in for framing a common civil code of the country. Now to sort of briefly wrap up on both the jurisprudence on interactive principles and the jurisprudence on personal laws and Article 44, and whether there is a link between the two, or are they on completely different tracks. In some senses, Article 44 is an outlier in the directive principles, because the bulk of the directive principles articulate socio-economic goals. Arguably, even the principles concerning the prohibition of cow slaughter in Article 48 and the prohibition of consumption of intoxicating drinks and drugs in Article 47 are framed in socio-economic terms and not religious moral terms. Article 48 is if you look at the heading, it's improvement of agriculture and animal husbandry, and cow slaughter is tucked away under that. And the prohibition of consumption of intoxicating drinks, which really, if you look at the debates, comes from the Gandhian imperatives of prohibition on not drinking alcohol. And Article 47 is one that, again, if you look at the heading, it's on public health and nutrition. So the intoxicating drinks and drugs are put under that. One argument, of course, made by some, including members of the Constituent Assembly, was that the directive principles were a receptacle to which contentious items were consigned, and I did mention, people like Krishnamacharya calling them a constitutional dustbin. In some senses, this could apply to Article 44. In some senses, postponing what was a contentious or a controversial issue to some time in the future. But if the directive principles are seen as aspirational rights, and this is something that is present in other constitutions, the Uniform Civil Code was definitely seen by people like Ambedkar and Munshi as a goal that the state should strive towards. It wasn't as if they were sort of, they were putting it away. Ambedkar himself was definitely very much strongly in favor of uniform laws. But there is a significant difference between Article 44 and the other directive principles, some other respects too. And this is in respect to Article 44, which presents a situation where two fundamental rights potentially clash. And one is the equality before law, which are fundamental rights guaranteed in Article 14 and 15, and the fundamental rights to religious freedom guaranteed under Articles 25 and 26. So Article 25 guarantees individual freedom of religion, and Article 26 is more the collective religious freedom. In independent India, the issue of personal laws has, of course, played a very prominent role in the minority rights discourse, as well as in the aggressive Hindu nationalist campaign for uniform civil code. So this has complicated matters. So as I was mentioning, the Constituent Assembly, the Muslim members were very much against uniform civil code and maintenance of personal laws, and this through the course of the history, how has it played out, has become a fairly important, a very important marker of Muslim identity, the issue of personal laws. And on the flip side, it has become for the Hindu nationalists something that is has been traditionally on the top of their agenda. As of now, not so much mentioned in the last decade or so, but even if you go back to the elections in 1999, when the Vajpayee government gets elected, it is very much along with Article 370, which gives special status for Kashmir, as well as the construction of a temple in Ayodhya, what some people believe is the birthplace of the Hindu god Ram. So the Uniform Civil Code, along with these two issues, was very much at the centerpiece of the BJP's, the Bharatiya Janata Party's election campaign and in the election manifesto. So this has complicated the issue to a great extent. Through the Supreme Court, through its general jurisprudence on the directive principles, the article, if one might call it the Article 21 jurisprudence, has in fact pushed the Indian state to legislate on many of the goals prescribed in the directive principles. I was mentioning health, housing, education. So the Supreme Court has been somewhat successful in pushing the state to legislate. It's another matter whether to what extent these moves have been successful or not, but at least the legislations have happened. However, on the other hand, the court has been absolutely spectacular failure in its call to enforce or to get the government to legislate the Uniform Civil Code. And in fact, the Shahbanu case, and I didn't go into great detail on how the judgment pans out. As soon as the judgment is passed, there is a huge Muslim backlash, demonstrations in the streets, and then subsequently the Congress government under Rajiv Gandhi passes a legislation to nullify the ruling. So there's a Muslim Women's Protection Act which gets passed soon after, which nullifies the thrust of the court judgment in Shahbanu. So there are some who believe that Article and including Madhav, who's in this room, that Article 37 speaks to a political rather than legal process guiding actors. And if this is so, a crucial difference between Article 44 and the other directive principles is that the former continues to be extremely divisive. It was divisive when the debates in the Constituent Assembly were happening. It continues to be divisive. While on the other principles, there is a broad political consensus on the intent at least, even though there might be differences on the methods of implementing them. And this was again something that was raised by some of the Constituent Assembly members on the capacity of the state to enforce some of the, or at least go through with some of the rights mentioned in the directive principles on both things like education, on food. So there were real concern then and even later on the capacity of the state to implement these very broad goals. But there was at least a consensus on the intent of these goals. And just to illustrate this consensus, there have been recent legislations that have been passed. I've mentioned a couple: Food Security Act and the right to free and compulsory education. And these are all 2013 legislations, although the process went on for a while. But passed by a government that was well short of a majority, but it still managed to push through these legislations in some form or the other. The court's directive principle jurisprudence is often contingent on non-state actors using public interest litigation to bring unfulfilled rights to court. But for Article 44, again, there's a break here in the sense that the public or collective interest, which has been the basis of much of the directive principle jurisprudence, becomes problematic. So what is the public here in terms of Article 44? So in that sense, Article 44 has just not been an outlier in the directive principles, in the set of directive principles itself, but it has also stymied the obstructed the court's attempts to get the state to act on it. So I think what I'll do is I'll stop here, and I did have one brief thing to end with, which is a short clip of which now All India Radio has actually put up some of these landmark speeches, etc. online, and there is a very short clip of Ambedkar speaking on this whole process, not on the directive principles in particular, but kind of gives you a sense of some of the tensions inherent in this process of constitution making. And this is one, a clip, an excerpt from a speech that he makes in the very early days of the Constituent Assembly, and I'll just see if I can get it to play. It's an audio clip. So. Oh, yeah.
Is the audio?
Our difficulty is not with regard to the ultimate. Our difficulty is with regard to the beginning. Mr. Chairman, therefore, I should have thought that in order to make a start, in order to induce every party, every section in this country, it would be the act of greatest statesmanship for the majority party even to make a concession to the prejudices of people who are not prepared to march together. And it is for that I propose to make this appeal. Let us leave aside slogans. Let us leave aside words which frighten people. Let us even make concession to the prejudices of our opponents. Bring them in so that they may willingly join with us on marching upon that road, which, as I said, if we walk long enough, must necessarily lead us to unity.
Okay, on that note, and
we have a healthy amount of time for questions. So, Ronojoy, would you mind fielding your own questions?
yeah, sure,
Okay,
yeah,
sure.
yeah.
I'll ask one to start.
Yeah.
So, as you know, all of this is quite far afield from anything that I have first-hand knowledge about. Sorry. So, I'll just ask a point of information question. I mean, in the narrative that you told, I guess I have two questions about the narrative that you told. First, is there a specific argument that you want to make that the narrative is intended to support? That's part one. And the second part is sort of within the field of people who discuss this range of issues, say the directive principles and the fundamental rights, what are some of the controversial, I guess, what are some of the controversies within those conversations, and sort of what is your position on them?
Right. Yeah, no, I think the argument, or if I might call it an argument, is really trying to understand. One is why Article 44 is placed within the directive principles, because what I'm trying to argue is that it really is an uncomfortable fit if you look at the other directive principles. So
is this a question of why it was placed?
Yeah,
or what
that's,
and historically why it was placed?
Why was it placed, and then what kind of impact that actually has on the trajectory that Article 44, which is then becomes, in other words, trying to explain a very contentious issue in independent India. So it's trying to, and I don't think I have definitive answers, but trying to sort of grapple with that, with these two questions. And you were also asking about the sort of the debates on the directive principles, and they're sort of.
I guess I just meant within.
The scholarship.
Amongst scholars who are discussing some of the similar topics, what are the sort of relevant issues of controversy, and where do you find yourself in relation to them?
Right. No, I think one basic question is the utility of something like the directive principles itself. Why would you want to have a set of fundamental rights which are enforceable by the court, and then have another set of 16 or 17 directive principles which are constitutionally at least not enforceable by the court, but are there added on to in some senses guide the state in its governance. So there have been interventions, as I mentioned right beginning from people like P.K. Tripathi in the 50s saying the directive principles should be extremely critical, should be a fulcrum of the state's policies. It's not that the directive principles not being judicially enforceable does not make a difference, and that in some senses becomes part of the sort of court's trajectory in interpreting the directive principles. So I think there is at one level a debate on as to what why at all the directive principles as opposed to fundamental rights. And I think another trend of scholarship is trying to see how the directive principles, the ideas in the directive principles have been used by the court somewhat creatively to push the state to legislate on certain issues like right to education, right to health, and those are some of the issues that the scholarship has looked at.
Ranjay, thanks. A lot to discuss, but just on this question, right? I mean, so I'm kind of just reading your evidence and argument, and actually, Article 44 doesn't seem like an outlier, right? It doesn't seem an outlier in the sense that if you take one of the purposes of directive principles to be, this is a goal that cannot be immediately realized, right? If you just take that as a basic, that's essentially what's happened, right? You'll do it when the legislature is ready, right? It's taken 60 years for education, and frankly, I mean, as it happens, both the food security bill and the education bill are actually relatively relevant in achieving the objective. They've come after the objective has been achieved, right? So empirically, it's actually the same story. There was a bunch of issues they thought the legislature wasn't ready to do for various reasons. I mean, in some cases, there might be financial implications. And, if this were to happen in the next 10 years or next 15 years, I mean, I'm not sure in your framework why you think this is actually an outlier. Right. In fact, the judgment 2 weeks ago, right, on the adoption case, right, but again the court takes a very, essentially the court says, look, the legislature should do it, and it'll do it whenever it's ready. So the first question is why you think it's actually an outlier?
Why I say it's an outlier is if one sort of looks at the sort of history of the directive principles and comes out, if you go back to the 31 Calcutta resolution, the social economic rights, which in some senses form the foundation of directive principles, and if you look at the rest of the directive principles, maybe if you, as I was mentioning, if you sort of leave aside the cow slaughter or the prohibition on alcohol, but again they are very much part of sort of broader. So they're very much socio-economic rights, and this was the thrust. Even when Ambedkar, if one looks at the Constituent Assembly debates and the sort of documents around it, they were very much seen as socio-economic rights. So in that sense, I sort of see Article 44, which is very much there is a social dimension to religious law, of course, but it is willy-nilly a religious issue. So in that sense, I see it as an outlier. But if you look at the narrative of treating the directive principles as a set of principles as a set of ideas which you postpone, as you are saying, for the moment, because they are either controversial or not feasible. And as you mentioned, it took 60 years for the different legislations on food, education to come about. So to postpone it indefinitely, or at least into the future, in that narrative, I think it's not an outlier. But if you sort of look at or at least I would argue, if you look at the idea behind the directive principles and what it should embody, Article 44, it seems to me, is an outlier. I don't know whether I'm.
Yeah, I mean.
Yeah.
So just to follow on that, I mean, the one thing that somebody could say, right, is that every provision in the directive principles is an outlier.
Okay.
Because, I mean, so even just on the socio-economic rights point, right, but this is not true. Like, look at 51, right?
The
respect
international,
for international law.
Yeah.
That's a real outlier. I think that's the real outlier. Because it's the only provision in the whole Constitution that doesn't deal that actually deals with international law, right? It could potentially be a far more, but there was one way in which I thought if you really want to run the outlier story, you could run it in one way, but that's different to the way you're suggesting. It's possible that the unique thing about 44, it's that it's the only provision in which there might genuinely be a conflict with fundamental rights.
Right.
I don't know if there's any other provision where that becomes so stark. I don't mean that as a matter of constitutional practice. As a matter of constitutional practice, the starkness of conflict has been clearest in land reform, right? So that's all been justified through directive principles and then sort of right to property and all, right? But potentially there is a situation where you might, and a lot of the debate, these in the Constituent Assembly and so on, is specifically pressed in that way, right? That in that sense, this is a real, like, it's incongruent with the rest of it. And with the others, it need not be so, right? Like, you can have right to life without public, I mean, there's a lot of open textureness there, right? And I was wondering whether you thought that was the case. Whether you thought that what was interesting about 44, and the one way in which it might be an outlier, is that it's the one provision in the directive principles that just can't exist with part 3 otherwise.
Right.
And that's not true for any of the other provisions.
Right. Yeah, I think I did briefly mention that, and in the way that the Shah-Bano case was being framed by Justice General, the clash between Article 44 and that's another sense, I think, maybe that justifies the outlier position. Is it fundamental clash between Article 44 and the right to equality provisions, Articles 14 and 15. Whereas the other provisions in directive principles can sort of feed off there is no direct contradiction between the fundamental rights and the directive principles, which is something, again, you
have to be careful how far down that road one goes, right? Because part of the problem is the fundamental rights, depending on how you interpret them, are also internally inconsistent. Right? So you could actually make the argument that the freedom of religion clause, the way it's framed, is actually inconsistent with the equality clause. Right? So, I mean, in a way, the challenge, right, interpretive challenge is, if you take the normative structure route, the Indian Constitution does not, I mean, the form of the Constitution, right, and the formal legal structure in which it's articulated is not perfectly symmetrical with the underlying normative framework, because the form is a product of political compromise, not just between, in the directive principles, but actually, the exception clauses, various other things, even in fundamental rights, right? You could argue property was this bizarre outlier at one level. Why was it even in part 1 in the first place, right? So, if you accept that tension, then, I mean, I guess the question is what hangs on saying whether it's an exception or not, right? I mean, there are lots of sort of these anomalies. What's the big normative stake in saying it's an exception? I mean, I agree with the normative conflict point, but it doesn't kind of do the legal work.
I think I might take some time to respond to that, but I think there is a school of thought that the Constitution itself is premised on a series of compromises, and as we were saying, the various fundamental rights are then undercut. So we were discussing the right to equality, and of course you have the Constitution itself introduces reservations, quotas. So the right to equality gets, there are several caveats to rights to equality, right to freedom of speech. So the fundamental rights itself has so many caveats that some of them become contradictory in themselves. And in terms of Article 44, where I was coming from was the outlier argument was one, as I was saying, that I thought it does not mesh well with the other the directive principles, and of course, as Mother was saying, and I mentioned earlier, that it does clash with some of the fundamental right provisions. But I'm also sort of interested in the puzzle, and to come back to Parimal's question as to why Article 44 gets put into the directive principles, except for, of course, if one would argue that just to sort of keep it on the back burner, because people like Ambedkar and Munshi and others and influential Constituent Assembly figures are very much set on unification of law, doing away with personal laws, and there is this sort of in the debates itself the idea of unity, not just for law but for the incipient nation, is a very important sort of narrative in the debates on the Uniform Civil Code. And
so just one small point on
Yeah,
that.
yeah.
Sorry, but the unity thing, right? Again, the internal tension. So you can also read it has Article 44 has also been read as a kind of counter majoritarian clause, right? I mean, in some ways, right? So you want unity, but you don't want unity produced through majoritarianism, which is what reform of Muslim personal law by a parliament predominantly Hindu would mean, right? I mean, whether you agree or not with that is not, but in a sense, right? And the reason it's become politically important is that it's performed that function, right? Not just of the kind of religious identity, but as a kind of statement of counter majoritarianism, right? That we agree with the goal, but, right? So it's unity, but not a unity produced through majoritarianism. And in that sense, you could argue it's performed. I mean, that's another interpretation of why it's in there. And the conflict between the legislature and the court, and that's the difference between this, right? If you were taking the exceptional clause, is in no other case does the question of majoritarianism arise per se, right? Right to education and so forth, right?
You mean on the directive principle?
On directive
Yeah.
principle. In this case, this is the only case where, for the purposes of projecting legitimacy, if you enacted it and all Muslim MPs opposed it, right? There's a particular issue about that in terms of legitimacy, which would not arise in majority, right? In the other, right? So it's the question of unity, reconciling unity with a form of counter-majoritarian representation. And since we have not solved that in our democratic politics, we can't solve that in our law.
Right. Yeah. Yeah.
Somewhat of a naive question here. Wait for the microphone, please. Sure.
Sound like you're next.
I'm making the assumption that the Constitution is the law of the land, that both the President, the Executive, and the Parliament abide by whatever is written on it. Is that correct? The Constitution being the law of the land that rules basically whatever the Executive and the Parliament does in context.
Yeah.
Is that okay?
Yeah,
Is that
yeah,
it?
yeah.
So I'm going to go back to then Article 21 and liberty and life, and I just want to find out whether that expansion of Article 21, protecting human dignity, you say that there was somewhat of a public revolution of sorts to try to increase it. And I'm looking here at the Constitution, and it seems that from 21 on, most of the things that you list on that revolution are the next articles that follow. Right to education, right to health, this and that. What was the pushback from the general public on this revolution that you mentioned, if any?
Right. No, I think the court used used a very expansive notion of dignity of life and due process, yeah, to push the government to put in place policies on the right to housing, employment. So I think these were policies which were for the I don't think neither the public nor the government had a problem with in terms of the the goal itself, but as Patil was saying, and I was mentioning, there were concerns about the capacity of the state to implement these things, whether the state could enforce the right to education between the ages of 16 and 14 or whatever, whether it had the wherewithal, or providing right to food to each and every citizen. So I think there was, in that sense, there was no pushback from, I think the court was putting it out there, and then over time these legislative enactments happened. Whether they were flawed or not, whether they did what they were meant to do is another matter. But these things happened, which for the uniform civil code thing, because of the sort of contentious nature, did not. So.
Thanks a lot. I really appreciate it.
Ronojoy, can I ask you two related questions about basically about the vision of the Constitution, and particularly as understood through the directive principles and the fundamental rights. It's not central to your argument, but it's these questions come up while in your presentation from me, which is the first question is really what is the vision of the Constitution towards individuals and communities? This whole discourse of unity. You have a passage here from one of the members of the the Assembly, Aladi Krishnaswamy Iyer. It's very interesting. He says, we are departing from the past in regard to an important particular, namely we want the whole of India to be welded and united together as a single nation. Are we helping those factors which help the welding together into a single nation, or is this country to be kept always as a series of competing communities? So, what is the normative position basically on collectivity? Does it envision a nation of basically a state and individuals, or will we have robust, meaningful communities? I ask this also because other arms of the state, whether through census or surveys, are often looking at the population as communities, primarily. So, is this how do you see the division here of the Constitution? That's one thing. The second thing is, again, going to the sort of, I guess, the genesis of the Constitution. This 1931 Karachi resolution has this language of Swaraj or Ram Rajya in there. Then you have Irish Constitution. Then you have the Constitution. The directive principles are full of terms like freedom, equality, dignity, justice, rights. The modern and scientific development of agriculture, and so what do you see then as the sort of, and you say this has been developed by, what is it, the microcosm of India?
Yeah.
Right, so what are the sorts of ideas and ideals that you think ultimately go into the formation of these directive principles?
Right. Yeah, the first question on the stress on unity, and you quoted Aladi Iyengar and the rights of individuals versus collective, and I think given the time when these debates were happening, of course, partition, the Constituent Assembly starts its session in 46 before, but partition is a reality, and most through the debates there is this overwhelming sense that group rights or collective rights is definitely should be subordinate to sort of individual rights. And you quoted someone, but then there's Radhakrishnan, there are others who are sort of talking about, we should not be in a situation where there are sort of watertight compartments where each group, similar language existing, and there's direct mention of the personal laws, which a lot of people think will lead to that kind of compartmentalization where each group has its own sort of laws, and there is no national integration. And one thing to keep in mind is that the one of the demands, of course, the one of the sort of linchpins of British the colonial policy was the separate electorates and that was something that the Constituent Assembly was very much against the idea, and of course we don't have separate electorates, religion-based separate electorates in the Constitution. So that also is an indicator of the way the events were going, and I think, and to sort of come back to one of Pratap's ideas, the uniform civil, the idea of letting the minorities have personal laws was one sort of guarantee for the minorities, because you already had taken out the separate electorates. So this becomes, and on the separate electorates, the Muslim members are not particularly vocal. I think they've sort of accepted the notion that this is not going to be something that the Constitution will put in place, and there is actually surprisingly not that much debate on this particular issue, whereas the Uniform Civil Code is something that the Muslim members hold dear. So I think that so this is in some ways a compensatory kind of right given to the Muslims, and on the influences on the Indian Constitution, and what there are, as I was saying, the 1931 resolution has a strong Gandhian element. It talks about Swaraj, Ramrajya, and then one could argue that the Gandhian influence on the Constitution is it's there. Of course, you have the panchayats are again. There is a one article in the Directive Principles. And then the prohibition of alcohol is very much during the debate. Gandhi comes up, but one could argue that the Gandhian influence is somewhat minimal on the Constitution and the constitutional process, whereas the influence of the American experience, the Irish Constitution, a lot of the Constituent Assembly members, do admit to having been influenced by the influences, and I had mentioned B.N. Rao, Rao, he does mention in his writings, the sort of impact, because he does go on these tours of America, Ireland. He meets Justice Felix Frankfurter in the US, De Valera in Ireland. So there are these other influences, I think, that are probably more important in the way fundamental rights are framed, and possibly also the Directive Principles, which can be directly ascribed to the Irish experience.
Sorry, just a comment and asking. Sorry, sir. This 1931 you talked about. The Swaraj or Ramraj. Is it a Gandhian influence, or rather a B.J. Tilak? Because at that time he was very much the focal point. Almost on a very rightist kind of way. He was more interested in the Swaraj than Gandhi. So do you think is it?
When it's Tilak.
Yeah.
No, I think.
I think 26. This was the time 1926 when Tilak was kind of at the forefront. And the Swaraj concept is probably Tilak than Gandhi's.
No, of course,
Swaraj is of course Balagangadhar Tilak.
Yes.
Yeah.
So that's what
So in history textbooks and sort of popular history.
No, but this concept is
Swaraj is my
sorry.
Swaraj is my birthright is sort of a popular quotable
but
quote
it was Tilak.
It
was Tilak in 1926 who brought it into the political arena, and made it something.
Sure, he might have the idea itself. But I think by 31 it was very much, the Gandhian notion of Swaraj, which was very
Even
much. I would
also,
think.
if you see that, he always mentioned that directive principles, first Article 39C, 39, 40 on.
Who's this?
Didi Basu.
Yeah, Didi Basu. Yeah.
Yes, my knowledge is limited to that only.
No. No.
So that's, he mentions that Gandhian principles. This
Right.
first part of the directive principles, the Gandhian principles. They categorize it like that.
Sorry, being an outsider,
No.
just
The influence of the British occupation of India and how that played with the Magna Carta and the United States Constitution. How did do you see that played a major influence on the Indian Constitution being occupied by the English with their set of government values?
Right. No, of course, nothing can be sort of divorced from the British, the colonial phase. So a lot of the ideas, including the parliamentary form of government, etc., are really, in some senses, borrowed from the British. But to just briefly, since you bring up the influences, and I was addressing some of the influences on the Constitution, even the idea of separate, personal laws for different religious communities is something that, the British put into place, and there is this famous, 1774, 72, this regulating act passed by Warren Hastings, who was the first Governor General, and there is this sort of thing that he says about the Hindus shall be governed by the Shastra, the religious texts, and the Muslims by Quranic principles, is something then has a long life, and there are sets of codifications going on even during in the British phase, and this does definitely play out in not just the debates, but on contemporary discussion about the uniform civil code. Yeah. So they did definitely have an influence.
I think we have time for one more question. There is one, otherwise you have one? Good.
Sorry that I joined in later, so it could be that this might have already been discussed. But I was wondering that does Article 344 or the presence of this particular article, does that have any bearing in terms of how we put religion vis-a-vis right to free speech? The precedence, sometimes the way it is that it should not hurt religious sentiments. Does that have a bearing? Means these two different kind of streams placed differently in Constitution, but do they have any mutual correlation?
No, I think the freedom of speech thing, it doesn't have a direct bearing on the uniform civil code, but I think on the larger question of religious freedom and the limits thereof is very much probably when there's been a lot of discussion on Wendy Doniger's book, and of course there's been several such instances going back to Salman Rushdie's, and of course what is used there is not so much provisions in the constitutions, but provisions in the penal code. What is it? Section 295. 295. Yeah. So
Malicious intent.
yeah, anything that can cause yeah. So I think those are the provisions that are used, and that can be used perniciously. But on the other hand, people can completely go scot-free. So if you sort of look at someone like the late Bal Thackeray, there were several things that he had said would have sort of should have ensured that he was in prison, but that didn't happen. So that I think it sort of ends up as a political question. When it's enforced, when it's not, who's petitioning the court on what issue. So it's again there are these inconsistencies in its application.
Great. Well, I'm afraid that our official time has come to a close. I think that Dr. Sen Ranjoy will be around a little bit afterwards if you want to finish up with him. But please join me in thanking Ranjoy for his really interesting talk.